You may remember that Prince, the rock legend, passed away in 2016. But did you know that his estate is just being wrapped up now, nearly 7 years later? And do you know why? That's because Prince had no estate plan whatsoever, no will. And as a result, people came out of the woodwork claiming an interest in his estate. In this video, we're going to show everything that went down relative to Prince's estate and the probate battle that succeeded his death, and how all of that could have been prevented. I'm Mitch Greene, a partner at Kramer, Greene, and for the past 35 years, I've helped business owners in various industries, including healthcare, protect their business from unforeseen circumstances. In each video, I like to share insightful and actionable information that will protect your assets, wealth, and business. So check out the rest of my video on my site or channel. Prince passed away in April of 2016 at the age of 57. At the time of his death, his estate was estimated to be worth around $157 million. Since he passed away with no known children and unmarried, by law, his 6 siblings stood to inherit his entire estate. However, since Prince did not leave a will or have a trust, this left his estate vulnerable to claims. And as many as 45 people turned up alleging they were related to him in one way or another. By the time his estate was finally settled in 2022 and his siblings were officially ruled as the heirs to his estate, there was hardly anything left in his estate. Because Prince didn't have a will, he wasn't able to address in the will who his family members were, who his beneficiaries were, who got what, or who didn't get anything. So as a result, he had siblings, half-siblings coming to claim an interest in his estate. We had individuals claiming to be his love child. As a result, there was tens of millions of dollars in legal fees spent litigating Prince's estate. So when you die without a will, you're not able to direct who gets your assets. The state of Florida writes a will for you, and that will may or may not be consistent with your intent. Most people don't want family members and others to battle over their estate for many years after their death, wasting much of the estate's assets in the process. Now, Prince didn't have a will, in part because I know he didn't trust lawyers. But as a result of not having a will, tens of millions of dollars of his estate was wasted in legal fees and paying estate taxes. As a result of the $150 million of his wealth, only a small portion ultimately went to his family members. So what should Prince have done? Well, first, he should have had a will. The will could have set forth specifically who his family members were. Could have listed those family members that he wanted to include in his will, and it could have listed those family members that he wanted to exclude in his will. So that would have clearly set forth who his family was and who got what and who didn't get anything. Another important thing in a will is to designate a personal representative or executor, and that is the individual or entity that will administer your estate. And that's typically a trusted friend, relative, or business advisor. So you have someone in there that you know and trust that will administer your estate consistent with your intent, as opposed to having the court appoint someone in that capacity, as was the case with Prince because he died without a will. Now, as important as a will is when you die, there are other documents that are more important if instead of dying, you become disabled. And those are as follows. And that is a durable power of attorney. If you have a durable power of attorney and you become incapacitated, you name a trusted individual or entity to handle your personal and financial affairs. And it's in the document you have set forth who will serve as your attorney in fact. If you don't have a durable power of attorney, then ultimately your family members and others will go to court to battle who will serve as your attorney in fact. An additional document that's important to have if you become incapacitated is a healthcare surrogate. As was very prevalent during the pandemic, if you become ill and can't make decisions regarding medical care, admission to medical facilities, medical procedures, you would name an individual who would have the authority to make those healthcare decisions. So as you can see, the vast majority of problems can be avoided just by having estate planning documents, whether it's your will, trust, durable power of attorney, or a healthcare surrogate. By having those documents, you're in charge of your future. Whether you're trying to protect your assets, start a business, sell a business, or navigate the law within a business, we provide a one-stop shop for everything. If you have questions surrounding your business and legal needs, schedule time to meet with our firm today and take the first step in protecting your business and financial future.